Buckle up, guys. Today we are diving into a courtroom scenario that quickly turns tense. Our defendant insists on representing himself in a probation violation case, despite clear warnings about the risks. The judge meticulously explains his rights and consequences, stressing there's no shortcut in the law. Signing the waiver, he steps into uncharted territory, setting the stage for a legal lesson in humility and self-representation. This opening perfectly sets the stakes and suspense.
165.
Yes, sir.
Okay, you're in court. Let me see what we got here. It's a motion to revoke probation has been filed in this case. You have the right to have an attorney represent you in this matter. If you can't afford to hire an attorney, I'll appoint one. Do you know what you're trying to do with regard to an attorney?
No attorney, sir.
Alrighty. Somebody give him a waiver form then.
But
You have the right to hire your own attorney. Like I said, if you can't afford to hire one, one will be appointed, no cost up front to you. If you choose to represent yourself, you have to follow the rules of evidence and procedure just as if you're an attorney. There's no special treatment. Are you going to influence any alcohol or drugs right now?
no, sir.
Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. If you've reviewed the form and want to waive it and proceed today, representing yourself, you can sign it at this time.
Yes.
Here the tension escalates as the judge outlines the probation violations, unpaid fines and missing drug and alcohol evaluation. The defendant tries to explain payments in confusion but admits he neglected the evaluation. Every statement counts in court and you can feel the pressure rising. The judge emphasizes probation is a privilege, not a right, reminding viewers that ignoring rules can carry serious consequences. The drama is subtle but powerful.
Right to an attorney. I'll accept that waiver. I'll allow you to represent yourself. You understand you have the right to contest the allegations. Do you have a copy of the allegations, by the way?
No, sir. On the probation violation?
Yeah.
I believe it was for the remaining payment of the probation, because that was
Right. Also failed to provide proof of obtaining drug and alcohol evaluation. Those were the allegations.
on to do which one?
We'll bring you.
The drug and alcohol evaluation?
Yes.
Okay. Alrighty. I did not do that unless I had done it with and sent it to Chris before, but yes, sir.
All right. Well, we're going to bring you a copy of those allegations here. All right. You understand? You have a copy of those in front of you, the affidavit alleging the violations?
No, it was the wrong paper. He's grabbing it right now. But I understand, sir. I do believe that I had forgotten the last time I talked with Chris, I do believe he had said that, and I had forgot about it and just thought it was payment.
The uncertainty over fines and payments introduces suspense. Did he pay or did it go to collections? The courtroom waits, highlighting how small missteps become pivotal in probation hearings. The judge decides not to punish for money but stresses the importance of the drug evaluation. This part builds tension as the audience realizes even minor negligence has weight in legal proceedings. The suspense is layered with frustration and anticipation.
Test the allegations that you violated probation at a hearing in an open court. It's the state's burden to establish a violation by a preponderance of the evidence. You have the right to present testimony of witnesses and other evidence on your behalf if you want to. If a probation violation is established or admitted to by you, I can continue, extend, modify, or revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, sir.
Do you understand all your rights as I've explained them?
Yes, sir.
All right. It's alleged that you failed to make payments as required on your court costs, fines as ordered by the court, and that your last payment was back on November 5th of 2021, and now you have still have a balance of $418. To that allegation, do you admit or deny?
That I paid that up in full. Whenever I paid that, I believe it was this last week or the week before, and then scheduled for the court date for today.
Is it paid up?
The prior, I had made arrangements. My mom had come over and to the court and paid everything remaining because I had moved down to South Texas, and then but they had added more charges, and then but the drug evaluation part, that I had forgotten all about that. But I mean, there's no record of like I have not been in trouble.
At this stage, probation officers and prosecutors recommend revocation, intensifying the drama. Representing himself now proves risky, as the defendant faces pressure to explain or defend his actions. Discussions about previous warrants and compliance failures emphasize that past negligence follows you into court. Every comment and pause adds to the suspense, showing how self-representation can magnify the stakes in an already tense environment.
So you're saying your mom paid off your fines or whatever? It's paid off?
Well, and originally she had come up here to pay them. She paid everything they had on file, and then they had added that last $418 after she had come here to pay.
So the balance is $418 still. Is that correct?
No, that was paid last week or the week before.
And somebody just go look.
We don't know.
We have no way of looking now. So let's skip that because
She said if it went to collections and he paid collections, we haven't been able to get it from them.
it may have went to collections. Let's just skip over to the next one. It's alleged you failed to provide proof of obtaining a drug and alcohol evaluation as ordered by the court. To that allegation, do you admit or deny?
I admit I did not do that.
Okay. I'll find that you, Mr. Marcinski, right now the court has no way of checking into any of this. I think it's been sent to collections is what I'm being told. So they don't know what's been paid, what hasn't been paid.
And if he has a receipt.
Yeah. Okay. Are you fine with skipping over the payment, Mr. Marcinski, at this point?
Well,
I'm not going to have a way of making a finding on it one way or another anyway. That's what I'm telling you. Nobody knows.
It appears to me that he is stipulating as of the date of this affidavit, he had not paid it. So the fact that he paid it 2 days ago or a week ago doesn't alleviate the fact that he committed this violation.
Well, that's okay.
I'm not going to contest that he hasn't paid as of today,
Right.
but it would seem to me that as of the time of this PV affidavit, that amount was still
It's all
outstanding.
academic. I don't put people in jail for not paying their fines usually anyway. So
Now the defendant starts offering excuses for missed obligations, accidents, distance, and forgetfulness. While the courtroom listens patiently, the consequences loom large. The tension is at its peak as viewers see the danger of relying on luck over legal counsel. This segment demonstrates how small oversights can spiral into major repercussions, illustrating the fragile line between leniency and enforcement.
you knowingly, willingly waived your rights. I'll accept your stipulation as to the second violation. I'll take the first one under advisement until stuff can be sorted out. I'm just not going to get into that right now. It's not really necessary. State's recommendation.
Judge, I may defer to Chris on this one. Looking at my file, we're a little light. All I see in here, my last notes in this file were when I offered Mr. Leesman a plea from the felonies that Kerwin had charged him with to a misdemeanor. The very next thing I have is the PV affidavit. And then my most recent document in the file shows a no bond warrant for his arrest. So obviously that at some point was lifted because he's bonded out and sitting in front of us.
I don't think so. I think he had us put on the docket and showed up. I think the warrant's still outstanding is what I'm told.
Or
Okay.
As far as we know. So
So I would probably ask Chris what he thinks is appropriate. At this point, if the case is paid in full, my primary cause for doing what I do is to try to get these folks into drug and alcohol treatment to help them get over their addictions. And it sounds like even as of today, that hasn't occurred in this particular case. And I see now that 3 years, almost 4 years later, I don't know what the benefit of that is, but there has to be some consequence to the violation. I mean, pretty much just disregarding of the probation. So I think at this point, Your Honor, I would probably request a sanction and then for the case to be terminated if it has indeed been paid in full, which I'm not contesting based on his statement that it has been paid. I would also ask the court to maybe ask Chris Hollis what he thinks is appropriate, at least as far as the sanction, and he may be able to even educate us about the payments and other things.
Your Honor, Mr. Leesman was on probation for almost a year, and he was on call-in reporting because he was a resident of Texas. Last time I spoke with him was on February 8th of 2022, and I informed him that he needed to come to Kansas so he can sign an extension of his probation due to the fact that he had not completed his drug and alcohol evaluation, and he didn't make, well, he still had an outstanding balance of $418. He told me that he's not going to make the time to come to Kansas and that if I need to file an affidavit, then just go ahead and do it. And then, of course, we haven't heard from him in over a year, almost 2 years. So my recommendation is that his probation is revoked.
all right. Mr.
And
Lee,
when he did call in, Your Honor,
Okay.
it was very sporadic. He would miss call in, report in. I'd have to call him, try and track him down. So he wasn't even really good at even that. So
Here comes the climax. The judge makes the final decision. Probation is revoked and the defendant is sentenced to serve the original 6 months. The courtroom is silent, suspense fully realized. This is the moment where self-representation backfires and viewers witness firsthand the harsh reality of ignoring professional advice. Every second emphasizes accountability and the consequences of underestimating the law.
I do apologize for the forgetting of that. I'd gotten in another accident right around that time before it was October it was October before that February I had talked to him. So I'd been healing up and I forgot about that drug and alcohol evaluation. And whenever we had talked, I had asked, he said I had to be here tomorrow to sign the paper. And I was asking, because I couldn't come from Port Aransas at that time all the way to Kansas to sign a paper. And I was seeing if we could do it like over like fax or, over like e-documents. So I didn't have to come in person all the way to Kansas to extend it for me to go do that drug and alcohol evaluation. But I do apologize for forgetting about that part. And I could get one done as like today, as soon as we leave here. I just wanted to get this warrant taken care of, but I understand. So I apologize.
The host steps in with reflection, breaking down what happened and why it matters. He explains that a lawyer could have mitigated the outcome and ensured the defendant completed his drug evaluation. This part mixes analysis with suspense, helping viewers understand the full gravity of self-representation mistakes. It reinforces the lesson while keeping the story engaging and relatable, building a bridge between drama and education.
I want you to become a productive member of society. I think the only way you can do that right now is that you become sort of deterrence and encouragement for other people to follow the orders of probation. So I'm going to revoke and remand you to serve your sentence. Good luck.
Wait, sir, how long is it? I came up here I came up from Texas all right, sir. All right. How long do I have to do?
Whatever the original sentence was. I think we went over that, didn't we?
The original sentence was 6 months. I don't know if he's got any credit for time served on that.
Yeah, that's what it is, 6 months.
Or it was for a misdemeanor. I still have to do 6 months.
Yes, sir.
All right, sir. Okay. Is there any way to like that?
It's time to face the consequences. That's what's happening.
What?
State versus Colton Marceau, 23 CR 300025.
Yes, sir. Can you grab my phone right there, sir?
Sure.
Bye. Have a great time.
Wrapping it up, the host reminds us that decisions have consequences. The story ends with reflection, emphasizing legal responsibility and smart choices. As with most videos, viewers are encouraged to like, comment, and subscribe, ensuring they catch future content. The commentary leaves a lasting impression. Respect the law, understand your rights, and never underestimate professional guidance in high-stakes situations. See you in the next video.